Guten Tag, Dobry dzień. Mein Name ist David Chmielik. Ich bin
Good morning. My name is Damit Schmilik. I'm the founder of Slavonic Europe, and we are based in Brussels. I would like to welcome you to the press conference by invitation of the Serbski Sejm for taking stock of the ultimatum that had been submitted to the federal government in March, and we also want to announce further steps in this direction. I would now like to introduce the members of this press conference. Heiko Kosel, he's a member of the Serbski Sejm, and he's also the head of the legal committee of Nebelschutz.de. Jadwiga Biacek, she's also a member of the Serbski Sejm, and we also have a team of lawyers from Dorothy's three chambers. On the one hand, we have Margarita Cornaglia here, Professor Mark Weller, and joining us from the Seychelles is Stephen Powells. Today, the Sorbian Wendish people will announce its demands. There are 60,000 people who, this according to a survey from 1986, and in 2022, about 50,000 people said they are Sorbians or Wends. And overall, 25,000 people speak the Sorbian Wendish language and Upper Sorbian, and 7,000 of them speak Lower Sorbian. And these are the facts. And I would now like to hand the floor to Ms. Pjasnik.
Serbsko Sejm, Strovic, Vashitki, Jara Vutrobnie,
I would like to welcome you very warmly to the press conference here in Berlin. I'm very glad that we are able to enter in a dialogue with you.
A je reč našo zdavna ve Vúžici bydlaco ľudu. Indigene Jill
Heiko Kosel and myself will be speaking Sorbian. And first of all, I would like to summarize the ultimatum that we submitted on the 21st of March this year to the federal government, and it asked for the immediate termination of the boycott of further talks. We call for immediate negotiations with the Sorbian Sejm, and this in the framework of a cultural and educational autonomy. We ask for immediate recognition of as an indigenous people as in line with ILO Convention 169. We ask that apologies be made to our people, also for the treatment as it is made by the German government. And I would now like to hand the floor to Heiko Kosel. Thank you very much, and a warm welcome to you also from my side. Thank you very much for your interest in our topic that is really important for our people. Last Saturday, it was on the 1st of July, the freely elected parliament of the Sorbian Wendish people, the Serbski Sejm, stated on its 38th meeting in Cottbus that neither the federal government nor the federal state governments of Brandenburg or Saxony reacted in terms of content to the legal claims made in our demand paper or position paper of 21st March 2023. On the 23rd of June 2023, the federal government and the two state governments have allowed the deadline which we set for this purpose to pass without any substantive response. We, the members of the Serbski Sejm, are extremely disappointed and shocked by this behavior of the federal government and the aforementioned state governments. After all, we had decided to issue the ultimatum only after several years of efforts for a dialogue with the government officials, especially on the impact of ILO Convention 169 on the legal situation of the Sorbian people that had always been ignored. At the latest, with the classification of the Sorbian by the UNESCO as a threatened language, should be nevertheless urgent need for action, which should be recognizable in Berlin, Potsdam, and Dresden. We're also disappointed about the fact that the federal government continues to deny by its behavior history denial that on the federal territory of the Sorbian people an indigenous population group is resident, which corresponds to the objective criteria of Article 1b, paragraph 1b and 1 and 2 of the ILO Convention 169. But we're also shocked because we have so far regarded the governments in the federal government and the two states as value partners for the enforcement of human and civil rights. Especially of minorities and indigenous people. However, with the current behavior of government representatives towards our objectives, there is a serious risk that our country's reputation regarding respect for human rights and international law could be seriously damaged. The way in which the rights of the Sorbian people are dealt with becomes the yardstick of credibility for German government action abroad. If legal claims are ignored by the executive, it is legitimate and common practice to take legal action and appeal to the courts. We're also determined to do this against the state's ignorance of the rights of the Sorbian people, and this on a domestic as well as on a European and international level. In order to be able to tread this thoroughly difficult path, we have turned to a London-based international law firm whose experts specialize particularly in the areas of international law, human rights protection, law for minorities and indigenous peoples, and equal access to justice. We are pleased to have the opportunity today to present from the circle of these high-caliber experts an initial assessment of the legal situation regarding the judicial enforcement of the rights of the Sorbian Wendish people that we have called for. We are determinedly preparing to fight for our rights in court, which nobody may doubt. But at the same time, we do not close our minds to really serious offers of dialogue from the government. Thank you for your attention.
Das internationale Völkerrechtsexpertenteam kurz vorstellen. Zugeschaltet aus den Seychellen.
Well, it is now Stephen Powles who's joining us from the Seychelles. Mr. Powers is an expert for international law and human rights. Since 2019, he has had the rank of a King's Counsel in Britain, and in many international cases, he has already demonstrated his abilities in terms of human rights and international law and their protection and their defense in the former Yugoslavia, Lebanon, Jamaica. For professional reasons, he's based in the Seychelles, and he's joining us online today. Ms. Margarita Conaglia is an expert for indigenous rights and the violation of indigenous rights and also climate protection rights. I think in Lusatia it is an important topic as well, and in this regard she's also the founder of the climate protection rights Department of Doughty Street Chambers in London, the law firm that all three lawyers belong to. And she's also the head of the Department for Climate Rights Protection. Ms. Conaglia, as I mentioned, is an expert for indigenous rights, and it is recently that she took action in Guatemala, where the indigenous population concerning the violation of indigenous rights is receiving advice from her. She's been an assistant at the Supreme Court in London, as the direct assistant of Lord Kerr, the Supreme Judge of Britain. Professor Mark Weller is also with us. He also works with Doughty Street Chambers, and he has studied law, among others, in Hamburg, legal studies and political science. Professor Weller is an expert for international law and constitutional law. In this regard, he has also worked for the UN in New York for a long time, including close contacts with Kofi Annan, the former Secretary General of the UN. Professor Weller is also very active in the former Yugoslavia for the Kosovo government concerning violation of international law, and he's also worked at the European Institute for Human Rights and for Minorities. And by the way, it is the Ministry of the Interior of Germany, the state of Schleswig-Holstein, and the Kingdom of Denmark that fund these activities. Professor Weller, you have the floor.
Maybe tell him in English that you are passing the word.
Stephen, you have the floor now.
Stephen, you have the floor now.
Thank you very much for that very kind introduction, David. And also thank you very much to the Serbski Sejm for engaging this legal team from Doughty Street International to undertake this important project. Professor Weller, Ms. Conaglia and myself very much look forward to taking up these important issues in the weeks and months ahead. As many of you will know, the concerns of the Sorbs were highlighted in 2022 Advisory Committee on the Framework Convention for the Protection of National Minorities in its fifth opinion on Germany. The advisory committee noted the establishment of the Serbski Sejm and the challenge this represented to the claim of the Domovina to be the sole representative of the Sorbian minority. The committee further noted Serbski Sejm demands for cultural and educational autonomy and the recognition of Sorbs as an indigenous people. Now, we have been engaged to provide an expert legal opinion on what legal remedies are available to the Serbski Sejm in taking forward these aims. In these times of growing global tension and conflict, the recognition and protection of minority rights is an important cornerstone for all democracies in the pursuit of a more just, fair, and peaceful world. Over 30 years ago now, in 1992, the UN General Assembly adopted the Declaration on the Rights of Persons Belonging to National or Ethnic, Religious and Linguistic Minorities. In the words of the current UN Special Rapporteur on minority issues, this was in response to, and I quote, reconfiguration and an upsurge in violent conflicts in different parts of the world in which minorities' issues often figured prominently. It could be said that similar such global challenges are perhaps as acute today as they were in 1992. And it's for that reason that it's important to highlight that by engaging us as lawyers to advance their cause via legal remedies, the Serbski Sejm demonstrate their very clear and strong commitment to the rule of law and to pursuing their objectives through both the domestic and international legal framework. The rule of law firmly underpins any democratic society, and again, the Serbski Sejm's recourse to law highlights their commitment to the democratic process and to democracy. Now, we have been engaged as a small team of expert international lawyers based in the UK, but from Germany, Italy and the UK, to reflect on the available international legal remedies to the Serbski Sejm in advancing the following. Firstly, the indigenous and minority rights of the Sorbian and Wendish people. Secondly, to promote and protect the educational autonomy of the Sorbian and Wendish people. And thirdly, the recognition of the Serbski Sejm as a democratically elected representative body of the Sorbian and Wendish people for the purpose of engagement in a structured dialogue. As international experts, we have been engaged to consider a whole range of avenues of redress within the established international legal framework and institutions. I've already mentioned the UN General Assembly Declaration on the Rights of Persons Belonging to National or Ethnic, Religious or Linguistic Minorities. In the preamble to that declaration, it's noted that, and I quote, "The United Nations has an important role to play regarding the protection of minorities." So plainly, we will giving serious and in particular engagement with the UN Special Rapporteur on minority issues. We will also be considering the potential remedies via UNESCO, the International Labour Organization, and of course the UN Human Rights Committee itself, especially as Article 27 of the International Covenant on Civil and Political Rights stipulates that persons belonging to, and I quote, ethnic, religious and linguistic minorities shall not be denied the right to enjoy their own culture, to profess and practice their own religion, or to use their own language. We will also explore potential remedies via European institutions through the EU, the Council of Europe, and of course, the European Court of Human Rights. Now, these are only some of the international mechanisms that we will be considering over the coming weeks and months for the Serbski Sejm. It is, of course, reassuring for the Serbski Sejm to know that there are these potential international remedies out there that may address their very real concerns. In the meantime, however, perhaps before we get to the point of taking any concrete steps, it is very much hoped that those concerns can and will be addressed in Germany through dialogue and consultation with the German authorities.
Thanks a lot, Stephen, for your words and your explication. Ich würde nur gerne das Wort Frau Margarita Conaglia geben.
I would now like to hand the floor to Margarita Conaglia. You have the floor.
Representing the Serbski Sejm.
Yes, it goes automatically.
Are they all on?
All right. So as my colleague Mr. Pose just mentioned, a part of what we will be advising on are the procedural avenues of redress which are available to the Sorbian and Wendish people to enforce their rights. My colleague Mr. Beller will follow and address in greater detail the substantive rights underlying those procedural mechanisms. So in summary, the procedural avenues we will be looking at will be legal avenues available at the domestic as well as at the international level to seek redress for the alleged failure of the German state to guarantee the Sorbian people's various rights. And as mentioned by my colleague Mr. Pohls, these predominantly fall into rights to educational and linguistic autonomy, the right to representation, political participation, and freedom of association, and the right to have safeguards of cultural rights, including through appropriate funding, and finally, the right to be recognized as indigenous peoples. Now, the avenues we will be exploring can be broadly split in two broad categories. The first are UN-based mechanisms, and the second, non-UN-based mechanisms. UN-based mechanisms are both treaty-based mechanisms and charter-based mechanisms. The first, treaty-based mechanisms, monitor the implementation of 10 United Nations treaties that focus on specific subject matters. So, for instance, the Convention on the Elimination of Racial Discrimination or the Convention on the Elimination of Discrimination Against Women. The second type of UN mechanisms, charter-based mechanisms, are mechanisms before the Human Rights Council, as well as special procedures of the Human Rights Council. The latter are independent human rights experts who report and advise on country situation or thematic issues and who operate complaints mechanisms to resolve issues within their mandate. And as noted already by my colleague before me, the special procedure relevant here is the Special Rapporteur on Minority Issues. Finally, amongst UN mechanisms, we will also be exploring the facilitative complaints mechanism offered by UNESCO, which is primarily relevant to the Sorbs' cultural and educational rights. Taking a small deep dive into the main UN mechanism that we will be focusing on presently, the Special Rapporteur on Minority Issues. The Special Rapporteur receives communications on behalf of national minorities and has powers to investigate these concerns and engage in dialogue with states. It also reports to the Human Rights Council and the UN General Assembly on any concerns it has on the defense of minority rights, as it did most recently in his report submitted at the 52nd Human Rights Council session of the 26th of January 2023. The Special Rapporteur also runs yearly forums on minority issues, and we will likely be encouraging and advising the Sorbs to participate and engage in these forums. Finally, the procedures before the Human Rights Council and before treaty-based mechanisms may be available to the Sorbs, and particularly relevant may be complaints before the mechanisms under the Convention on the Elimination of Racial Discrimination, the Convention on the Elimination of Discrimination Against Women, and the Convention on the Rights of the Child. We will be exploring the requirement for the exhaustion of domestic remedies under these mechanisms, and particularly whether the Sorbs have access to effective domestic remedies in Germany, particularly in light of the findings of the fifth assessment cycle report of the Advisory Committee under the Framework Convention on National Minorities. Moving now to the second broad batch of complaints mechanisms, those that exist outside of the United Nations framework, we will be advising about mechanisms available at European Union level, before the International Labour Organization, before the Organization for Security and Cooperation in Europe, and particularly the Office for Democratic Institutions and Human Rights, and finally before the European Court of Human Rights. Focusing briefly on the ILO's complaints and representation mechanism, which is established under Articles 24 to 36 of the ILO Constitution, we will be looking at this one with particular attention. Under the ILO Constitution, workers and employers' organizations may raise concerns by way of written representations regarding a state's failure to comply with any ILO convention the state has signed. Representations are then examined and determined by a tripartite committee tasked to make findings on compliance and recommendations for change. Germany is signatory to numerous conventions, including the Convention on Freedom of Association and the Indigenous and Tribal Peoples Convention. We will be exploring and advising the Sorbs and the Serbski Sejm on their probable rights to access such remedies and to seek protection of their rights to organize and their alleged rights to be recognized as indigenous peoples. At EU level, we will be advising the Sorbs of opportunities to raise concerns and representations under the Framework Convention for National Minorities, and we will be advising on potential violations of the European Charter of Fundamental Rights and means to seek redress for any such violations, both domestically and through the European courts. Before the Organization for Security and Cooperation in Europe, we will be focusing on engagement with the Office for Democratic Institutions and Human Rights, and particularly via the yearly Human Dimension Conference held in Warsaw and the conference's supplementary meetings which take place throughout the year. Last but not least, we will be advising on the procedural and substantive dimensions of bringing a domestic claim for violations of the rights enshrined in the European Convention on Human Rights, as well as the potential to seek judgment of the European Court of Human Rights should domestic proceedings fail to address and remedy the violations of the Sorbian people's rights. I will now hand over to my colleague, Professor Weller, who will give an overview and a preliminary view of the substantive issues at stake. Thank you very much.
Thank you so much. It is always a pleasure for me to return to the United Kingdom for some 40 years, and it is testimony to the persuasive nature of David, who had a leading hand in organizing this meeting, that he has persuaded me to attempt to speak to you in German. Ja, Deutsch spreche ich schon, aber alle Fachwörter natürlich.
Yes, of course I do speak German, but of course I experienced all the technical terms only in English. So let me see how it works out. Here in this region there's a saying which is maybe still relevant for many of us. We are the people. And all the state power in a democratic power starts from the people. This is what the fundamental law in Germany says. And here we have a group, a people's group which organized itself, but the state says no. The state denies the contact with an organization which founded itself in order to protect or implement effectively the rights of this people. Now, we all have problems with inflation. We are supposed to build in a new heating system overnight and are supposed to watch TikTok to learn something. So we're all very busy. And there are only few who show the commitment to present themselves as democratic representatives. And if there are some, should they be turned down, or shouldn't we rather recognize that people make a step forward to stand up for the interests of their community? It sounds counterintuitive, strange, difficult to understand, because we all know that minority questions are most easily solved when you start early to solve them. That minority questions that keep being ignored over a long time are getting more and more difficult. And Stephen Powell's mentioned it, that in the 90s, Europe heard the appeal that now is the time to do something for minority questions. But of course, it should always be the others to do something. But anyway, we have the UN Framework Convention of National Framework Protections, which works out throughout Europe and provides rights. But the idea of ignoring democratic representatives, of course, it is comfortable for the government, which for decades had been creating a structure which allows it to engage allegedly with the Serbs, is negotiating with them, is handing over millions, and calls it a closed shop. But this is my special focus, this is contradictory to the people's right and the regulations of the minority rights, because the core of minority right is self-determination and your own representation of your interests. Self-determination means that you create your own institutions through which you get in touch with the government and other forces, and own representation means it is not the German federal government to tell the Serbs and Wends who will represent them. And this seems to be the core of the problem here, that you stand in front of a closed door for dialogue. How can this happen? Difficult to understand. I mean, dialogue is in the nature of a democracy, and the fact that we are now at a threshold between dialogue and legal dispute, this is why we are here, is amazing, because Germany sees itself as a kind of pioneer in view of implementing humans and minorities' rights. Of course, you're entitled to take legal actions if political dialogue doesn't work out. Therefore, it is a state under the rule of law. And the question, as Margarita pointed out, whether we are moving to all these failures of implementation mechanisms, this long list of mechanisms which you can apply to implement your right, it will show whether it works out. So there are three major claims here. Number one, the representatives of the Serbian and Wendish group of people want to organize themselves, want to determine their own form of organizations, and not just be represented by by a structure predefined by a government. Self-determination, or a kind of cultural autonomy, especially in view of education, where unfortunately there were some steps back taken the last years. And the third question, the Serbs, are they an indigenous people? If yes, the rights of the Serbs would be on an even higher level and beyond the minority rights. There would be considerable more demands and rights. So, to focus on these three questions in detail, I think we need to deal with three issues. Which are the legal foundations which can be applied to this subject? To begin with, in the Federal Republic of Germany, the people's right is regarded as right, as the customary right, as well as the treaty-based right, as long as these treaties are specifically enough to be applied in detail. If they are formulated more generously and do not contain any things that need to be implemented, they are regarded as guidelines for the government, but must be implemented or translated into national law. Which of these legal foundations apply for the Serbs and Wends? In particular, are they an indigenous people? And these legal specifications, what do they provide? And this refers especially to the political self-organizations. Later in our study, which we are going to issue over the summer period, we will especially focus on education questions like schools and so on. So the point is not to give detailed answers to individual questions, but to give a survey on what exists and what you can refer to. And part of this cascade from bottom up, national, federal states' right, Serbs' rights, national right, and other rights reflect the fundamental rights in Germany, and their individual and cultural self-determination, free development of the personality, freedom of religion, freedom to expression, freedom of association and assembly. And there is explicitly the right to form organizations like the Serbski Sejm, family, school organizations, and so on, and the right to political co-determination. All these rights exist also as human rights, so they reflect the Constitution and the international human rights. They reflect each other here. Worldwide, the United Nations, we heard it, as well as in particular in the scope of the European Council, where the European Commission for Human Rights is the outstanding paper. Coming to the minorities and minority rights, funnily enough, there is no universally applying worldwide treaty between the states. But the answer is states are nervous. Minorities are still a tricky issue for many states. Anyway, the United Nations issued a declaration, the Assembly, on minority rights, and this, together with the decisions of international human rights bodies, regional human rights courts of justice, provide a vast amount of hardened, robust legal conventions which apply worldwide. From this area of practice, of these very thin UN Assembly's declaration, a 700-page treasure of binding legal regulations were derived, which apply also in Germany. What's the title of Book 1? Title is Universal Minority Rights. And I'm too shy. Who published this book, this masterwork? Professor Mark Weller. Okay. So, firmly anchored on a universal level, no treaty, UN declaration, but this one implemented in a hard way in form of hard rights as opposed to soft laws and regulations. Following the conflict in Yugoslavia, there was the UN Convention on Minority Rights, Book 2. What is the title of Book 2? The Rights of Minorities.
Of the Framework Convention, which is about this thick, but it has attached to it an advisory committee of the Council of Europe that has been in dialogue for 30 years by now with all the member states, and has filled up the general provisions of the Framework Convention with jurisprudence that has led to, what would you guess, how many pages of hard minority rights?
Listen, we have around 700 pages.
700 pages. So that actually the states that negotiated, die Staaten, die Framework, die Rahmen, das Rahmen.
The states which negotiated the Framework Convention had the idea it would be a kind of guideline. So we don't want to put anything too hard in it, which we need to implement later. But 30 years later, it became and consolidated itself as a practice which can now be demanded by groups, and the Sorbs belong to these groups. Who published Book 2? Oh, well, Professor Mark Weller published it. And so far, applicable to Europe, we have a convention which started to make states interested in dialogue with the European Council to further develop minority rights. And one of the most important issues which the advisory committee took from the convention is political representation, political participation on minority. Is there a standard work from Oxford Friends? Yeah, maybe. Isn't that even sicker than the former ones? 900 pages.
Politische Teilhabe von Minderheiten.
Und wer hat es
Political participation of minorities, published again by Professor Mark Weller. Okay. The question of how minorities can participate in the political process is no longer a marginal question. It is a core question, a 900-page question, where one individual title, Article 15 of the Framework Convention, created such a lot of practice which you can apply for your benefit. And of course, there's the question of indigenous rights. Is there maybe there's another book on this one?
Wie heißt das denn?
What is the name of that one? It is the UN Declaration of the Rights, the UN Declaration of Indigenous Peoples. And who published it? Looks again like Professor Mark Weller. But there's Jesse Homan also on the front page. Okay, so what you can see in front of you here is the substance of the universal and European minority rights. And on top of this, in part 4 also of the indigenous rights. It contains a lot of contents, you must admit. And starting from this, we want to start working. And the question is, volume 4, does it fit in? Sorbs and Wends are then indigenous people. The federal government in Germany was quite generous. It ratified the ILO Convention 169 under the precondition, provided that it shall not be applied to Germany. What a surprise. Why? Deciding in favor of ratifying, signing a convention if you say, we have none of this stuff, we don't need it, but we do want to help you, the others, to handle your indigenous groups in a better way. Well, the Sorbs and Wends are the indigenous people. We will deal with this question. There's a dispute. I mean, peoples in independent countries, this is the definition in English, is reading it out.
Or a geographical region to which the country belongs, at the time of conquest or colonization or the establishment of present state boundaries, and who, irrespective of their legal status, retain some or all of their own social, economic, cultural, and political institutions. And secondly, there has to be self-identification as indigenous or tribal by the members of the group itself. Before Deutschland die Konvention ratifiziert hat, hat der
Before Germany ratified the convention, the scientific service of the parliament studied the question whether by chance or by fault obligations must be accepted in regard of the Sorbs and Wends. And the study said that the features of an indigenous people are fulfilled. In fact, or allegedly. It is a people more than 1,000 years old, still sitting in the same region, has its own culture and so on. But he also says that regarding the working living conditions, the social economic systems don't show many differences to the majority population, and the self-identification might be doubted because a representative of the Domowina denied that they were an indigenous people. The Domowina is the tool with which the Federal Republic of Germany is managing their Sorbs in a certain way. So the question whether Sorbs are indigenous people, is it completely open? I mean, there's room for discussion. I think you must not interpret a racist feature into it by saying indigenous peoples are only cases where during the colonial era whites invaded these countries, suppressed these people, and where these people are still oppressed people in their own original country. There are indigenous peoples in Northern Europe and in Russia, and there is no doubt that this definition applies. So, I hear my presentation is too long now, therefore, in brief, we mentioned human rights. There is the freedom of association, and this is often seen together with Article 25 of the International Pact of Civil Rights as a guarantee that they can found organizations like Serbski Sejm. The Declaration of
Most of the rights, the right to participate effectively in economic, social, cultural, public life is expressly stated. The right to establish and maintain your own associations. And to maintain your own association means not to have associations imposed upon you by the state. Sie schaffen Ihre Vereinigung nicht.
You create your organization. It is not the state which creates it. In brief, the Framework Convention has the famous Article 15, effective participation of minorities, and expressed in various general comments of this article, it other details. Minorities must create their own associations. There can be an umbrella organization, but this umbrella organizations must be representative. And all organizations must be represented by the umbrella organizations. You cannot have an umbrella organizations which excludes some groups. And this was clearly expressed by the European Council. In regard of the SORBs, thank you, Dr. Kluge and the other legal advisors. You made a lot of progress with the advisory committee in the Council of Europe. And like Stephen Powles told us, in the fifth state report of this year, the Serbski Sejm was mentioned in an undiplomatic way. Federal government of Germany is criticized for assuming that all Serbs can be represented in a homogeneous way by just one body.
Cannot be expected to identify as a homogeneous group. Authorities need to take an inclusive role, an inclusive approach, reflect accurately the variety of views amongst persons belonging to national minorities. And ganz zum Schluss
and at the very end, specifically made for you, Serbski Sejm says,
to create inclusive consultation processes which facilitate and take into account different perspectives within national minorities. So here we have already an international institutions picking up your claim and starting to implement it. And my last thought, you may think, what does it matter if some international advisory committee makes a recommendation? Governments are extremely sensitive to it. Für Regierungen ist das ein schwarzer Tag.
For governments, this is a black day. If an international mechanism like this one's criticizing government, this is impressive. And I'm afraid for the German federal government, if they do not enter into dialogue with you, there are more black days coming up. Thank you very much.
Thank you very much, Professor Weller, and I would now like to open the floor for discussions. Any questions, comments, or observations? If you'd like to ask a question, please make use of the microphone.
Ans Mikro, bitte. Ja, auf jeden Fall.
Mijn naam is Rob Zavelberg, ik kom uit de Nederlanden.
Hello, my name is Dagobert. I'm from the Netherlands. We are a small minority in Germany, but I'd like to ask a question, maybe a question of understanding. I work for an Amsterdam-based newspaper. I would like to know, well, we are living in the year 2023. You are talking about a people that is 1,000 years old. Why is it precisely now that you come up with these accusations that you are not properly being noticed or represented? And for more than 100 years now, there have been efforts to enter in a dialogue between the Serbs and the German government, and also, you know, during the time of the Emperor, the Weimar Republic, to always get things on the right track. Why is it happening precisely now? Why are you not only turning to the federal government, but also the local governments? Saxony, for example, as I understand, there was a Prime Minister, Mr. Tillich, and at that time it would have been possible to address the cause of the Serbs. So why is it happening precisely now? Why so late? Why not any earlier? That's one part of my question. And then I also have questions for others. The traditions of the Serbs that may not be so famous, maybe you would like to introduce them, because not everybody is familiar with them. And
Dan nog die vragen.
Namely, representation.
Aber ich habe verstanden, Sie haben ein sorbisches Rundfunk gibt es.
Serbian
Freedom of association and freedom of speech.
Germany has freedom of association, freedom of speech. So there are many freedoms in Europe, including Germany.
Ob die Rassismuskarte in Deutschland nicht ein bisschen
racism card, you know, are you not showing it a bit too clearly? Thank you.
Heiko Kosel.
Tja, Cernitko, warum erst jetzt? Sie haben ja vy ste tohle pokazali na ten čas posledných 100 let. V tej době posledných 100 let jsme v Němsku měli všelakore formy kniežerstva, jsme měli jedno kniežerstvo, jsme měli jednu demokratické republiky ve Weimarské době, my jsme měli jednu záhubnou diktaturu nacionalsocialismu, my jsme ve Vukoče měli potom indiánský systém. A hakle nitko, tylko po zjednoczeniu możemy powiedzieć, że mamy
It is only after German unification that we can talk of a truly democratic state. All the time before that, before unification, practice has shown that it did not make sense to work with totalitarian or monarchy-based structures to talk about the rights of the Serbs. We had to notice that a democratic state does not work this way. We had to establish that in Saxony our Serbian schools were closed, our culture was reduced. Of course, we were able to preserve many aspects. We do have a theater, the Serbian Institute. We were able to preserve that. But this, again, was, after unification, was put to question. it was always necessary to find a form or resort to a form of a political struggle. We were always seeking dialogue, the political dialogue, but now we had to see that it has not worked as yet. The Sorbian language is threatened, and the EU has classified Sorbian as a endangered minority language, and we decided that things can't stay the way they are. So we need a reform, and the ratification of the ILO Convention 169 has very much motivated us, so that we thought this is a very good point of time, and the ILO is a very good basis for this dialogue. And why also against the Brandenburg and Saxony governments? Well, because we have a federal system in Germany. Many topics that are important to us are really a federal thing, so a matter of the regional states. For example, the education system. This is an essential question, and this is why we addressed it. We need autonomy in terms of education, and the federal government is still able to tell us this is not our competency, it is the regional state's competency, and for that reason we also protest, or we also take action against the regional states of Brandenburg and Saxony. Well, traditions today wouldn't be enough to talk about all those traditions and customs. I think we have many of them, and it is no coincidence that it has been included in the list of immaterial cultural heritage of UNESCO. For example, the feather picking of cocks, which has its origin in the Christianization age. And this is supposed to signal the fertility of the land, and there are many customs that are really unique among the Sorbs, but we also have traditions that are influenced by Christian traditions, the Christian religion. For example, our Easter habits, and this was before colonization. We have many also religious traditions, and we would like to invite you to come to Lusatia to familiarize yourself with our culture. Racism, I hope I've understood you correctly. It is also in Lusatia that we have different forms of racism, and there are different racist atrocities also from the part of the radical right, and also assaults on people who speak Sorbic. And it is about our rights, and these rights include the protection of against assaults on Sorbs that unfortunately we had to experience as well. It is also about our right to we would like to emphasize that we are a democratic state.
Der pravo Stanislav Tilić biše jeden Serb, jako sakski ministarski prezident. Fakt, że ja tam jakoś...
That's correct. Mr. Tillich was a prime minister in Saxony, and the fact alone that he was the prime minister has helped a lot. And many civil servants that otherwise doubt our demands have formally talked to us, and nonetheless, there was one pitfall, which was
Ministerski prezydent wszystkich Saksów.
He had to be the prime minister of all Saxons, and sometimes he was afraid to be doing too much for the Serbs.
Erstens, der Herr Klim fragt, wo kommen die Zahlen her, die ich am Anfang genannt habe? Das sind die 150.000 Menschen in der Lausitz, die angeben.
Well, in Lusatia, we have many aspects. There are many people who know that they are of Wendish or Sorbian descent. Well, these 150,000, where do they come from? This is a survey from 2022, and these 25,000, they come from a publication of the Serbski Institute. This is the Bautzen and Cottbus-based Serbian institutions. And there was another question for our legal experts from London, Doughty Street Chambers. And the question is as follows concerning the election to the Serbski Sejm in 2018. And there were 882 valid voting slips. Simultaneously, there was a survey in Saxony on the question of do you want the Serbski Sejm? 1,314 answers were cast. 95% voted against the Serbski Sejm. So has the Serbski Sejm, Mr. Klim wants to know whether it is entitled to talk on behalf of people from Serbia and Wendish people, and to call itself the legal representative of the Serbs and Wendish people. So this is a question for the English colleagues.
Vote for the CDU in Germany, and 30% vote for, let's say, the SPD or the other way around, does of course not mean that the party that hasn't won the election doesn't exist and doesn't represent anything. So obviously there can be more than one body representing. If 1,882 participations have answered the Serbski Sejm itself, and in a public opinion poll, some others said they do not wish to be represented by the Serbski Sejm. That doesn't mean that Serbski Sejm is not also, along with others, a legitimate representative of the population. And I would have thought that over time that number might increase. But of course that is a matter for the Sorbian and Wendish people to determine over time. But my impression is that the Serbski Sejm does not claim that it is the only exclusive representative of everyone. I think it builds its constituents over time, and it wishes to be treated by the German federal government as one significant representative one needs to engage with.
Vielen herzlichen Dank. Gibt es weitere Fragen?
Thank you very much. Are there any further questions? Thomas Gerlach from Taz, die Tageszeitung. Well, the three legal experts have very well explained what routes or avenues could be taken. Nonetheless, the result would be, or the answer would remain open. I also heard between the lines that you want to continue to maintain the dialogue. Are you waiting for offerings from the federal or the regional governments to enter in a dialogue, or what are the priorities and what are did you not receive any response? Okay, officially the ultimatum exhausted, but did you get any unofficial offerings to enter in a dialogue? So what will the next weeks and months most likely bring? Well, this is a question for our colleagues. Well,
We budeme ležiti zamovitost nitka vizo pola kniežastva. Pola Serbského kniežastva, kaj tiež pola Sakského a Braniborského. My sme všetko spýtali do dialoga przyjść. My sme viacejkrát listy písali, my sme naprašovania stajili na Serbskú uninu, kaj tiež na krajnú uninu a všetko sme pak ignorancov doživeli, pak výrazné odpokazanie. Nitka potom, że sme nasz ultimatum wozywili, są przyszli takie cyle kedźbliwe pohyby, chcę raz brać. Jeden braniborski sobodziewacza, jedno ministerstwa, also jeden sobodziewacza, żaden wietnik.
A Brandenburg expert, well, a normal office staff member turned to us in order to be included in the mailing list and in order to see what concerns will be placed in the center of our activities. It was similar in Saxony. In this case, the ministry well, a leading staff member also wanted to be included in our mailing list in order to pursue our activities. And I do hope that after today's press conference, we will see even more movement, that we could ultimately enter in a dialogue. We continue to be open to dialogue, and nonetheless, we have been making efforts all the time, so it is not our fault that this dialogue does not yet exist.
Possible reactions to from or to signs to signs from the German government. The question was actually, what would you expect concretely? What could happen? How should the German authorities behave?
I can come in if you want, David.
Yes, please.
I don't think it's for us as legal experts to say what the authorities should or shouldn't do. I think the point that we want to make is that we are exploring legal remedies that are available to the Serbs over the coming months. There are certainly, as we've highlighted during the last hour, some very concrete steps that the Serbski Sejm can take. But having said that, it's always good to talk, and dialogue is always better. So even though we're lawyers and we're advising on the legal remedies, and particularly the international legal remedies that are available to the Serbski Sejm, it's hoped, I would have thought, that in the weeks and months ahead, that dialogue can be engaged between the German authorities and the Serbski Sejm to see whether there is any common ground in order to perhaps avoid taking any of the concrete steps that we'll be looking into over the next intervening period.
Thanks a lot. There is another question. Bitte eine Frage ans Mikro. Dankeschön.
And once again, he's using the microphone. Very good. Good afternoon, my name is Krüger and I work for Super ILU. Professor Weller, you said in your explanation that it is very well worth to address minority questions at a very early stage. That really sounds like a scenario Well, but what if it doesn't happen early enough? Now, with a view to the claim of the Serbs for self-representation, what would happen if it doesn't happen soon enough? Well, my remarks aimed at the fact that if you tackle an issue early, that you can solve it more easily. I did not suggest that all kinds of escalation, including violence, should be used. I think these are very friendly people here in this room. These Serbs are certainly not terrorists, but what characterizes this case and what makes it different from others, that the means of dialogue were preferred until the very last minute. And if this is not wanted, although we don't understand why this is the case, but if it's not wanted, then the answer would be legal remedies. And this is a characteristic of a democratic society. And then what is going to happen during the summer? Well, we are lawyers. We do exactly what we are told to do.
So we have been instructed to develop over the summer the detailed legal analysis of the entitlements of the Serbs in international law, and to offer, even more than we could do today, specific advice as to what legal steps the Serbs can take. This can be soft mechanisms, the United Nations, Council of Europe, bring international agencies into the dialogue. I mentioned governments are very, very sensitive to that. There can be legal steps in the courts in Germany, which is less for us, but we would be able to contribute an expert study on what the entitlements of the Serbs are, which can be brought to bear on such a process. And finally, it can be formal human rights cases before international bodies, even the European Court of Human Rights. And the European Court has the power to make binding orders in relation to Germany ultimately. So our instruction really is that by the end of the summer, we have helped the Serbski Sejm to be in a position to take the next steps. And it's their political judgment what these steps ought to be. But we would only be involved in this on the basis of the assurance that they are all dialogue or legal steps to come back to the thrust of your original question.
Vielen Dank, Herr Professor Weller.
Many thanks, Professor Weller. Are there any further questions?
Wenn dem nicht so ist,
Well, if that's not the case, I would like to thank all participants of this press conference very warmly. Thank you very much for being with us. Thanks for joining us. Thank you for joining us, and thank you for sharing your positions. And in conclusion, I would like to pass the floor to Jadwiga Placic for a final remark.
Na zjazkové a krajine kniežastvo a namawiamy was jako...
Well, we ultimately ask and call upon the German government, the moral, legal and reputation level in the European level. If all this is dear to you, then please come back to the or sit down at the negotiation table with us and avoid any legal action which would not suit you. Thank you.